This is Jonathan Page again, Chief Legal Officer of InPrime Legal. I am on a mission to get your business in prime legal condition. Today we are going to discuss the legal risk associated with choosing a name for your business, service, or product. And we're also going to discuss how you can navigate these risks more safely to ensure that you profit from the decision to choose a name in the first place. Now let's start with a brief story. A prospective client came to us after receiving a cease and desist letter from an attorney. The attorney's letter demanded that the prospect cease all further use of their restaurant name because, according to the attorney, it infringed on his client's name. After some due diligence, we determined, one, that the attorney's client in fact sold similar food items as our prospect, and two, that the attorney's client had been using the name in the marketplace for much longer than the prospect had been using it. Now, although we were able to avoid the prospect from being sued for money damages, this legal threat was still very expensive to the prospect. Once they became a client, we had to advise them on changing their name. They had to change all of the signage in front of their restaurant. They had to change and redo and reprint their menus and marketing collateral and their business cards. They had wasted a lot of money on radio advertisement, and they just simply reversed several years of goodwill that they had built in the name. So let's discuss some tips on how you can avoid this from happening to you. So there are two questions you need to consider when choosing a name to market your services. First, is your name protectable? And second, if protectable, then does it infringe on some other name out there in the marketplace, some other trade name? And when looking at this first question, whether the name you've chosen is protectable, courts often look at a continuum of protection, or what's been called a spectrum of distinctiveness. So let's look at that next. Here's the spectrum. Okay, so I made a mistake, and just to keep you sharp, this should be weak, and this should be strong. So on the weak end is generic marks, and on the strongest end are fanciful marks. And we have descriptive, suggestive, and arbitrary in between. Now, a generic mark refers to the kind of generalness of your goods and services in general, the kind of broad goods and services. A good example of this, for example, would be soda. So if you're in the beverage industry and you go out and sell sodas and you call your beverage company soda, well, there's no real way to distinguish your goods and services from everybody else's goods and services out there in the market space. This would be generic. It would just be a general description of your goods and services. Another example is Apple. If you're in the business of growing and distributing apples and you name your company Apple, then there'd be no way of distinguishing your product from anyone else's product. So you wouldn't be able to get the exclusive right to use the word Apple in conjunction with or in association with your goods and services. That would be a generic name. Looking next on the list is descriptive marks. Descriptive marks merely describe your products and services. A good example of a descriptive mark would be Appalicious. Again, if you're out there growing and distributing apples, then Appalicious would merely describe your goods. You sell delicious apples. Appalicious. Now, a descriptive mark can get protection over time if consumers come to exclusively associate your name with your goods and services. So over time, if they associate Appalicious with only your apples, then you can acquire what's called secondary meaning and actually get that mark protected. Looking next on the list is suggestive marks. Suggestive marks refer to the nature, quality, or characteristic of your goods and services. With some imagination, a suggestive mark, the consumer can maybe figure out what your goods and services might be about based on the name itself. A good example of a suggestive mark would be Blu-ray. Blu-ray refers to the blue laser that is used to read the plastic disc. And a consumer with some imagination might be able to determine, based on the name Blu-ray, that it has to do with some sort of digital data format. That would be a suggestive mark, and a suggestive mark can be protected. An arbitrary mark is a name that is used out of context. Let's go back to apples. If you were on Steve Jobs' board when he was creating his company, and he told you that he wanted to name a computer company Apple, you might have looked at him like he was crazy. What does Apple have anything to do with computers? At least from the perception of the marketplace, Apple has no association with computers whatsoever. This was the brilliance of Steve Jobs. Because he named it after an arbitrary name, he was able to author the meaning out there in the marketplace. He was able to tell consumers how he wanted them to think about his company and how he wanted them to think about the term Apple when they thought about it in association with consumers. So arbitrary marks, in fact, get very strong protection. Fanciful marks, which is on the other end of the spectrum, get the strongest protection. These are completely made up words. An example of this would be Kodak. Kodak is just a made up word. And again, like arbitrary marks, the business owner can go out there and be the author of what their made up word means to the marketplace. That's why it gets so much protection. So keeping this continuum in mind will help you determine whether or not your name that you have chosen can even be protected. Clearly, if you've chosen a generic name, you're not going to receive any sort of protection at all. If you choose a descriptive name, you may be able to receive some protection if over time the consumer associates your name with your goods and services and exclusively with your goods and services. And of course, suggestive, arbitrary, and fanciful marks are the ones that will get you the most protection. So even if you choose a name that can be protected, that doesn't mean that you get across the finish line. The second question is whether the name you've chosen infringes on someone else's intellectual property. Now, the standard out there is likelihood of confusion. Let's take Coca-Cola, for example. If you went back into the beverage industry and you were going to sell sodas and you decided to call your company Coca-Cola, then Coca-Cola would likely have a big problem with this. You simply left out the C in Coca-Cola. Now, technically, your name, Coca-Cola, is a different name than Coca-Cola, but they're so similar that consumers out there are likely to confuse Coca-Cola with Coca-Cola and think that your products and services are somehow associated with Coca-Cola. Somehow the source of your goods are from Coca-Cola. And this would be infringing on Coca-Cola's intellectual property. Another tip to keep in mind when doing this is an easy and cost-effective way of making sure your mark doesn't infringe on someone else's is to first start with a simple Google search. If you Google your name and you come up with other names that are very similar to or the same as your name, and the companies that you're finding provide the same goods or services that you do, then you'll know you can eliminate your name and you should move on to the next one. But once you exhaust your search and you find that there doesn't appear to be any other names that are infringing on your name, that doesn't mean you're done. You still need to engage an attorney to do a more comprehensive search. The attorney will look at the United States Patent and Trademark Database, at the Secretary of State's database. They'll look at trade journals and industry journals and go out in the marketplace and do their due diligence to determine if there are any other names that are similar to yours that may cause infringement. Another tip is when you're choosing your name, if you choose a descriptive or suggestive name, then it's going to be more likely that you are infringing on someone's mark out there in the marketplace, because when a person starts a business, they tend to gravitate when choosing their name towards descriptive and suggestive marks. Their thinking is that I want a name that describes my goods and services. And so the goods and services you provide, the first likely source of infringement or the first name that you're going to come up with is one that's descriptive. If instead you choose an arbitrary and fanciful mark, which gives you the most protection anyways, it's going to be much less likely that you're going to be infringing on somebody's mark out there in the marketplace. It would just be a coincidence. You've made up a completely different word, or you've come up with this arbitrary association. The likelihood of somebody else coming up with the exact word or even similar word that you came up with made-up word, or to make, a similar arbitrary association is just going to be less likely to have happened. So these are some tips in helping you not infringe on somebody else's intellectual property. But again, engaging that attorney and doing a comprehensive search is really the way to go. These are a few key concepts you should consider before choosing a business name or changing your name for purposes of marketing your goods or services. With these concepts in mind, this will help you navigate these risks more safely by reducing the likelihood or the legal threat of you infringing on someone else's intellectual property. Until next time, this is Jonathan Page with InPrime Legal, on a mission to get your business in prime legal condition.